On the record in Williams Distributing versus Smith, and this is case number 221405. You are Mr. Smith?
Yes, Your Honor.
Okay, and counsel, can you put your appearance on?
Yes, Your Honor. Gary Cooper with Clark Hill on behalf of Williams Distributing.
Okay. And this is the date and time set for better exam, is that correct?
That's correct, Your Honor.
Okay, so Mr. Smith, I'm simply going to place you under oath, and then I just typically, counsel, if you guys want to meet out in the lobby or wherever you want, I'm going to have more hearings going on in here.
Okay.
But Mr. Smith would just go with counsel there and provide whatever information that he's requesting. So if you could stand and raise your right hand, please. You solemnly swear or affirm that the evidence you're going to give today is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Okay. Thank you.
Thank you, Your Honor.
And Terry, Sharice Fink is out there.
And she doesn't-
Okay, then lock the door.
she doesn't- well, I mean, she's not a party.
Right, yeah, yeah.
File bill real quick.
Sure. So that's her case. Did you
Oh,
want
no,
her son's?
yeah.
Okay. So 245, here we go.
Taken off.
Oh.
Yeah.
Gosh, I just printed a new docket today. Maybe I haven't gotten it yet. Well,
It is not on my docket,
Oh.
so.
let's see.
it
Maybe,
is-
oh, no, 245. Oh, this is my old docket.
Oh,
And she's looking somewhere online that she's seeing it.
okay, so this one did get taken off,
Okay, well, good.
but we still have another.
Yes. Hold on.
Okay, we're on the record in Brilott versus Citizens, case number 2314183. That was set for hearing today at 1:30. It's now 1:35. Neither party has appeared for that hearing today. That was a control date set to check on closing documents and we're going to set this for another status conference at its next date and see if parties appear for that.
Hello, Your Honor. I'm sorry, for some reason I don't have audio. Can you hear me?
Yeah, I can now. Sorry, I was on my
Okay,
end.
perfect.
What case are you appearing on?
I'm here on the Brilott matter. For some reason, I thought we already entered this, the stipulated order of dismissal with prejudice on this. So I was kind of caught by surprise at this settlement conference. I imagine that this was what this is about. I've just reached out to Ron Paul, who's the defense attorney on this, to double check that we hadn't entered the stipulated order, and we will get it filed right away.
Okay, yeah, that was set at 1:30 for, that was a control date that the court set for that exact reason. You know, we're looking for the closing documents, and the file doesn't show that it's been filed, but you're saying that you guys are gonna get that taken care of?
Yeah, the settlement check's already been dispersed to the client. It's just a matter of getting the stipulated order filed, and we'll get it all buttoned up.
Okay, is that gonna be done like next 7 days, next 14 days?
I can ideally, you know, as soon as Ron gets back to me, by the end of the week, so 7 days, we should be able to get it done.
Okay, great. I'll note that for the file. If parties are going to submit that within 7 days, and then we'll close it up. Thank you.
All right, thank you, Your Honor. Goodbye.
Bye. All right, I think we have everybody connected, so we'll go on the record in Joslin. I'm sorry, Shephard versus Joslin. This is case number 2414438. And if I can have counsel put your appearances on, starting with plaintiff.
Attorney Samara Slocum for plaintiffs.
Todd Millar for defendant Jeffrey Joslin.
Good afternoon, Your Honor. Brad Benzinger on behalf of K&K Heating and Cooling.
All right, thank you. This is set for a scheduling conference in this case today. Counsel, have you guys had a chance to talk about dates yet amongst the three of you?
We have not, Your Honor.
Okay. All right, starting then, Ms. Slocum, can you just kind of tell me what the basis of your claims are and kind of what you're looking for in terms of scheduling going forward?
Yeah, so the basis of it is Mr. Joslin had a rental property he was renting out to plaintiffs. There seemed to be allegedly some malfunction in the way that the furnace was operating and the way that it was maintained and fixed by K&K, which led to a carbon monoxide leak in the home for an extended period of time, such that the plaintiffs, all of them, had to undergo carbon monoxide testing, which all came back with very high levels. They are currently undergoing neurological testing to ascertain what the extent of that damage is and what that's going to be. And right now, they're scheduling about 6 months out, so it's going to be quite a bit of time. The youngest one is going to get in possibly in September, but Melanie Shephard won't be able to get in for that testing for about 4 to 6 months. So the discovery period may have to be a bit longer given that. But that's kind of the overview of the case.
Okay, Mr. Millar or Mr. Benzinger, anything that you guys wanted to add in terms of significance to the defense?
Your Honor, I guess hearing that, you know, we can set dates, however, a 6 months window to, if that's going to be the basis of claims that there's ongoing issues or permanent issues, and we won't know those till 6 months. Yeah, it's going to be hard to proceed with much of anything until that's been done, and then obviously having time after that to conduct certain things. I mean, we'll agree to disagree on some of the dissertation of facts, but if we're going to have to wait for that testing, you're almost looking at a year of discovery.
I
And
don't
this-
disagree with that.
And the 6 months was just given to me by my client. It could be sooner than that. That was just kind of the length that they were looking at.
All right, so Ms. Slocum, I mean, just based on what Mr. Benzinger and Mr. Millar have said, I mean, are you anticipating it's going to be that long before there's going to be able to, we're going to be able to have any meaningful discovery of, at least of your clients?
No, I believe meaningful discovery can be taking place. The neurological testing is more to see, what was the extent of the damage. There's still enough medical records. They've been going to the hospital. I believe there's enough discovery in there that we can get started and have meaningful settlement negotiations without having to wait that 6-month period.
Okay, all right. Well, let's do this. Let's set aside 6 months for discovery at this point. If defendants need to extend that out based on, new developments or testing that's taking place with the plaintiffs, then I think that would provide adequate cause to extend out the discovery dates. So let's start with a period of 6 months. I am going to put in the order that the parties are to participate in mediation within that period of time. Again, if we get up against that deadline and there hasn't been enough discovery or there are issues which would affect, the ability of all sides to come to mediation, then we can extend that date out. But in terms of the pretrial order, I'm going to set that mediation to occur within that 6-month period for discovery. Do you all believe that you'll be able to agree on a mediator when you get to that point?
Yes, Your Honor.
Okay.
Your Honor.
Okay, great. And then at this point, I don't want to set a whole bunch of other deadlines given what I'm hearing from counsel. So I think if we set an initial period of discovery, have a deadline for mediation in there, and then set this for a status conference at that 6-month mark to see where everybody's at. Obviously, if it mediates before that, then we don't have to worry about it. We could take that down. But are there any other dates that any of you want to set today, or does that provide enough of a framework to move forward?
Not on behalf of plaintiffs. That seems appropriate.
Your Honor, the only thing that I'm thinking about is there's a good chance that we might want some independent medical examinations of some or all of the plaintiffs. Is that something you would be willing to put in this order, or would you like me to file a motion for that?
No, I can put it in the order, and then Ms. Slocum, if you have a legal basis to object to IMEs of any or all of your plaintiffs, then I would anticipate you filing a motion to object to the IME, and then we can have a hearing on it.
Absolutely.
Okay. Okay, Mr. Benzinger, any other dates that I could address for your side today?
No, Your Honor, I think it's appropriate.
All right, so we'll send out an order with all of these dates in it. The court will also send out notice of the date and time for that next status conference at about 6 months. And we'll go from there. Thank you. Everybody's free to disconnect on this file.
Thank you,
Your Honor.
All right, if I could have both of you unmute, please.
Am I unmuted?
Yes, thank you. Okay. So, sir, are you Silas Ormsby?
I am.
Okay, and ma'am, you're Christina Ormsby, is that correct?
Correct.
All right, we're on the record now in Ormsby versus Ormsby. This is case number 2414428. The record should reflect both parties are present today by Zoom video. The purpose of this hearing today is for scheduling in this case. And the first question I have, Mr. Ormsby, from your side of things, have you discussed how to divide up any assets or debts of the marriage, and have you reached any agreements on those things with Miss Ormsby?
On most cases, the only thing that we haven't discussed is 2 points. One is tax. We have a pass for the IRS. And we have equity in the home that we haven't figured out how to divide.
Okay, Miss Ormsby, do you agree with that, or are there other issues that you're aware of?
When it comes to equity in the home was mine before I married him. So I'm not sure why equity would be brought up. He was never an owner on my house. And then we've never really discussed much. We separated some things, like he came to get some things. He still has things here. But we never really sat down and discussed too much. He said when it came down to like some of the credit card bills, one of the credit card bills that was regarding his business with his partner for wood, he said he was going to pay back, but that was pretty much the farthest the discussion has been.
Okay. All right. So what I'm going to do is have the two of you participate in a process called mediation. And that's where you'll meet with an independent third-party mediator who's trained in talking to parties and trying to have them reach agreements. So that person will conduct a mediation between the two of you. It'll be by Zoom like we're doing today. And they'll try to facilitate an agreement on those issues that you both have raised today. You're not required to reach an agreement. They're not going to force you to do anything, but they try to see if there's some common ground and some give and take where the two of you can reach an agreement on how to address those issues. And then I will set it for another hearing after that mediation. If you're able to reach an agreement, then we can finalize things at that time. If you're not, then we can look at the court setting further hearings for the court to make decisions about how to divide up those things. So I will refer it to the community mediation. They will be in touch with each of you to set up a date and time that works for you and the mediator. And then the court will send you a notice of the date and time of the next hearing here in court. Mr. Ormsby, do you have any questions about how we're going to go forward?
No.
Ms. Ormsby, do you have any questions?
No.
Okay, very good then. So wait to, again, follow up with those contacts once the mediation service contacts you, and then look for the notice of the date and time of the next hearing for court in the mail. And that's all I have. You're both free to disconnect at this time.
Thank you.
Mr. Conlon, can you tell me what case you're signing in on, please? You're muted.
Sorry, yeah, I was hearing for a 145 pretrial on the Joslin matter. Case number 2024-1 There's 5 zeros, 14438 NO.
Okay, I'm sorry. We did go forward with that. I thought I had all counsel on the line at that time.
That's okay, Judge. I made an appearance as co-counsel for the defendant, Joslin. And maybe you didn't
Okay.
have my appearance yet. I just mailed it in the other day. So you may not have me, but I'm sure Mr. Millar took into account my client's interests.
Yes. Yeah, Mr. Millar was present, and yeah, I don't have an appearance from you yet, so yeah, I wasn't looking for you on that one.
No problem. Sorry about the inconvenience here. So, all right. Well, thank you for the update.
Okay, thank
All
you.
right. Take care.
Okay, and the Stites file.
Sure.
Well, I guess I was looking for that Class versus Valencourt case. I thought it was up here at 1:30.
Oh, yeah.
So it was still, it is still on.
Oh, okay.
So I'll still call it. I'll see what happens.
Yeah, it's confusing having the two on the same day.
Okay, we're on the record in Stites versus Stites. This is case number 2414407. Looking at the file on May 6th, the parties filed written notice to the court of an attempt to reconcile. So the court will put this on the 6-month waiting period. Unless either side reopens the case within that time, then the court will dismiss it. And the court notes for the record, it's 2:04. The time for hearing today was 2 o'clock, and I don't see either party present. Next hearing's at 2:45. Okay, we have somebody joining on the phone with the last four digits, 4669. Can you tell me your name, please? All right, and I've got an RCP. Can you tell me who you are, please?
I'm Paul on behalf of the defendant, Valencourt, Your Honor.
Okay. All right, let's go on the record. This is Valencourt versus, I'm sorry, West versus Valencourt, case number 2314318. The record should reflect we do have Mr. Paul present on behalf of Valencourt. And there's somebody who's joined on the phone. They haven't responded to my request to identify, so I'm not sure who that is. And I don't have the other parties present. This matter was set for hearing at 2:45. It's now 2:47. Mr. Paul, have you been in touch with the other side in this case?
It's been a week or two. We're sort of at a standstill in the case, Your Honor, because the plaintiff, Blake West, has been charged criminally related to the accident, and his case is up for trial on June 27th. So we really can't do anything until after that trial is over.
Okay. Do you know why the other side hasn't appeared today? Does that?
I do not.
Okay. All right. Well, what would you like to do going forward today then? What do you think?
Well, I think we need to await the outcome of the trial of the plaintiff, because that trial concerns liability for the accident involved in the case. If the plaintiff is found responsible for the accident, my client is exonerated, specifically as to the plaintiff, but in my view, as to both plaintiffs, number one. Number two, if the plaintiff, Blake West, is found responsible for the accident, I think we may have a situation where the plaintiff's attorney has a conflict because he can't represent Blake West and the woman that was injured sitting on the back of his motorcycle, if Blake West is indeed responsible for the accident. It's a complicated situation given the criminal proceedings.
Okay, and you said that that's set to occur in June?
I'm told it's set for June 27th,
okay.
Before Tuesday Day.
Okay, got it. All right, well, I'm just going to reset this for another hearing then, following whenever I can get a date following that. And then I guess we'll see where we're at. If you happen to speak with Mr. Gilbert, who's plaintiff's counsel, please let them know that I'm going to be looking for a reason why they weren't present here today for this hearing.
Okay, I can do that.
And then the court will send out a new notice of hearing for that next status conference. Anything else I can address for your side on this case today?
That's all I need to address, yes, Your Honor.
Okay, all right, thank you. You're free to disconnect at this time.
All right, thank you, Judge.
I just saw the docket for a couple of weeks and I saw that Blake trial on there.
Mm-hmm. See that PPO file that we have?
Oh, page for Johnson and Chipman.
Yes.
So it's a 3 o'clock Smith and Smith.
As far as I know, it's on. I'm just in the middle of about 47 things right now, and I got to finish what I'm doing.
I'm amazed you look like you do.
Very gracefully.
Actually, pretty graceful.
Oh, thanks. Oh my God.
Good afternoon, Your Honor.
Good afternoon. Is that your client that you have with you there?
Correct.
Okay, great. And I've got Ms. Garno signing in here, so it'll just be 1 minute. Okay, Ms. Garno, if you can unmute yourself, please. All right, great. We're on the record now in Smith versus Smith. This is case number 2414431. If I could have counsel put your appearances on, please.
Laura Garno on behalf of the plaintiff, who is seated to my left.
Elena Lentz on the behalf of the defendant, Trent Smith, who is seated to my right.
All right, thank you. We're on the record here today for purposes of a pretrial conference in this case. On behalf of the plaintiff, Ms. Garno, can you kind of tell me where things are at from your side and what you'd like to see for scheduling so that we can get this matter resolved?
Sure. Pleadings are satisfactory. I have received the financial affidavit from Ms. Lentz's office. I am this afternoon with my client putting together all of the attachments that go with hers, and we'll be sending that over. So I think following that, maybe about 60 days allotted for discovery, and probably should have some court-ordered mediation in the event that we can't resolve this by exchanging offers. I don't believe that this is a case that would need to go to trial, but if the court wants to talk about that scheduling, I think probably a day would be sufficient to get it all taken care of.
All right. In terms of mediation, are there any complex assets or debts involved here where we would need an attorney mediator, or do you think community mediation would be sufficient?
There is a business, actually there's, well, one business that's kind of more established and up and running, and then a newer business as well. So there are those issues. I think it might be beneficial to have an attorney mediator involved in this case.
Okay. Ms. Lentz, what are your thoughts on the issues that Ms. Garno's raised?
I would agree that an attorney would be appropriate as a mediator. I think that the plaintiff has also made a request for spousal support. And so I think that could be helpful to have an attorney be the mediator. In regard to her comments on 60 days for discovery, I think that would be appropriate, conditioned that I receive plaintiff's domestic relations form within the next couple of days, Your Honor. I understand from Ms. Garno, she's working with her client on that. And I think that 1 day of trial would be appropriate, as the parties do not share any minor children.
Okay. Do you both think you'll be able to agree on a mediator?
Absolutely.
Yes.
Okay. So what I'm going to order in terms of scheduling is discovery to remain open for the next 90 days. We'll just build a little bit of extra time in there. And then I'll order that mediation is to occur also within that 90-day period. And then rather than getting this on the court's trial docket at this point, I'd rather see where you guys get through discovery and mediation. And then go from there. So what I'll do is set this for another conference at about 90 days. See if mediation was able to resolve the case, we can use that date to take proofs and finalize things. If not, then we can see whether the parties were at least able to narrow the issues and determine where to go from there. Ms. Garno, do you have any objection to that as a plan going forward?
Nope, I think that sounds great.
Okay, Ms. Lentz?
No, Your Honor, I think that sounds good as well.
Okay, so I'll put that into an order. I am going to ask counsel to just notify the court in writing in the next 14 days of your selection of a mediator. Obviously, mediation doesn't have to take place that quick, but if you can just let the court know who you've selected.
Yep, we can do that.
Okay, and then I'll put this all into an order. I'll get that out to the parties along with the notice of the date and time for that next hearing in about 90 days. On behalf of plaintiff, Ms. Garno, anything further I can address for your side today?
Nothing further, Your Honor. Thank you.
Thank you, Ms. Lentz. Anything further for your side?
No, Your Honor, thank you.
Okay, thank you. That concludes our hearing for today. All parties on this case are free to disconnect.
Thank you.
Oh, thank you. I was just realizing that, and so I'm just looking through it. Let me just merge an adjacent file.
I probably don't need to file.
Oh, okay, thanks. Let me see. Yeah, I'm sorry. I did not grab the wrong one. Today started out so well.
All right, looks like we have all the parties connected for our 3:15 hearing, so we'll go on the record here. This is not sure where that was coming from. I'm sorry. Court will go on the record in Binski versus AWI Delivery Services. This is at Otsego County case number 2219068. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon. May it please the court, Your Honor, Gerald Skupin on behalf of the Daniel Binski and the minor plaintiff.
And good afternoon, Your Honor, Kaylin Piper on behalf of the defendants.
All right, thank you. We're on the record here today for a hearing on plaintiff's motion for approval of the settlement pursuant to court rule because the claimant is a minor. I did have a chance to review the motion as well as the attachments that were provided with that. I had a chance to review the proposed order. Mr. Skupin, did you want to take some testimony from Ms. Dzinski today?
Yes, sir, I would like to do that. And before I take the testimony, I would like to throw one little curveball at you.
Okay. Sure.
The Michigan compiled laws were recently amended to allow a party that owes a minor money to pay up to $50,000, if you can imagine that. It's MCL 700.5102. I've already discussed it with Ms. Piper. I've discussed it with Danielle, and she's discussed it with Brooklyn, that we would like to, instead of setting up the conservatorship to save the estate money, and since it's only approximately $13,000, that the money go to Danielle Dzinski for Brooklyn. I'll take some testimony that they have plans for the money, including the Michigan Educational Trust, including a long-term CD, but then she wouldn't be required to report and go to the probate court to get money to fund whatever she might want to be able to give Brooklyn, if the judge would allow me to change the order to allow that. And it's, like I said, it's MCL 700.5102. If the court needs a quick look at it before we start the testimony. Or I could file another complete motion to ask you to look at it. Okay.
I don't think we need to do that, and I don't necessarily want to delay the hearing today since we've got everybody here. So I'm just going to go off the record just for a minute and take a quick look at that, and then we'll come back on. So if everybody could just hold. Yeah, if everybody could just hold on the line, that'd be great.
Thank you, Your Honor.
Okay, I've had a chance to review that statute. We're back on the record now, and I appreciate counsel raising that. I try to keep abreast of statutory changes, but I haven't had occasion to approve a settlement yet since that came into effect about 2 months ago or 3 months ago now. So I did have a chance to review it. I do think it's applicable in this situation, given the amounts, with some testimony, I think, which I'm sure you will do, Mr. Skupin, in terms of establishing the relationship of Ms. Dzinski to the minor in this case. So Ms. Dzinski, can you unmute, please?
Good afternoon.
Can you raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, thank you. You can lower your hand. And I just want to make sure I clarify for this record, you're not, I can see you're in a moving vehicle, but you're not operating that vehicle at this time,
No,
are you?
I'm in the passenger seat.
Okay, very good. Thank you. All right, Mr. Skupin, please proceed.
Thank you, Your Honor. Danielle, are you in the passenger seat because you are coming back from a job you're working right now?
Yes.
And are you the natural mother of Brooklyn Wilson?
Yes.
Have you and Brooklyn always lived together?
Yes.
When was the last time Brooklyn Wilson's natural father saw her?
It'll either be 9 or 10 years this August.
So he basically abandoned Brooklyn.
Yes.
Do you know the whereabouts of her biological father right now?
He is currently lodged in a prison, I believe, down in Adrian.
Thank you. You do understand that we're here today to approve the settlement of $20,000 for Brooklyn. Are you aware of that?
Yes.
And you understand that you and I have had conversations and I've explained to you what this means, right?
Yes.
So you understand that if Judge Mertz approved this settlement, that the case against Kaylin Thayer and the company she was working for will be forever dismissed, and that is all the money that Brooklyn will be able to get.
Yes.
Do you think that the amount of money that we negotiated at that in-person facilitation here with Mr. Barney was fair to Brooklyn?
Yes.
Does Brooklyn have any residuals, or she had any automobile-related treatment for at least the last 2 years?
No.
It's my understanding that Brooklyn has a small scar on her lower lip. Is that something that can be seen by somebody who is casually just looking at her?
I don't think if you didn't know it was there, it's not that noticeable, no.
And is it true that Brooklyn suffered from some facial pain, had to drink from a straw that you helped her with for approximately 2 or 3 weeks after the collision?
Yes.
You understand that I'm going to be paid an attorney fee from this?
Yes.
And you understand that I'm not charging any costs in this particular case?
Yes.
And everything that I've discussed with you and everything you've seen from the motion, are you satisfied that the settlement's in Brooklyn's best interests?
Yes.
And would you like Judge Mertz to approve this settlement?
Yes.
I see Brooklyn is on the Zoom and she's not with you, but I know that you have talked with her, and is she satisfied with what this is what she wants to do? Not that it really makes a big difference.
Yes.
We talked about that statute that the judge said seems like it would apply here, that MCL 700.5102. We talked about that, meaning that the defendant can pay my office and then I can pay my office to you direct. But that money is Brooklyn's money. It's not your money to spend how you please. It's to be spent on Brooklyn if Judge Mertz approves use of that statute and approves the settlement.
Yes, absolutely.
We've already talked about the fact that you've been looking at the Michigan Educational Trust for Brooklyn's education. You've been looking at a long-term CD, and there's other things you're looking at for the money besides just leaving it in the bank, right?
Yes.
And I know this doesn't hold a lot of water in the court, but you are under oath. Do you promise to use that money for Brooklyn's benefit and not yours?
Yes.
And I've known you for a long time and your mother for a long time, and I believe that that is true. So, Your Honor, I have no further questions.
Thank you.
Thank you. Ms. Piper, did you have any questions for Ms. Dzinski?
Nothing further. Thank you, Your Honor.
All right, the court has heard the testimony of Ms. Dzinski, as indicated by Mr. Skupin. The minor child, Brooklyn, is present by Zoom. I'm able to observe her here on the video screen. I've had a chance to review the medical records that were provided and other documents with the motion for approval of the settlement, along with the disbursement amounts. Based on all of that, the court finds that the settlement is appropriate given the nature and extent of the injuries suffered by Brooklyn as a result of the accident. My observations of her are consistent with the injuries as stated in the medical records and by Ms. Dzinski, as well as the lack of any residual, really noticeable or observable residual effects of the injury. So the court finds it would be appropriate. The court will approve the settlement and payment to Ms. Dzinski subject to the provisions of MCL 700.5102 sub 3. And so the court will just request, Mr. Skupin, that you submit a new order that reflects the application of that statute. and the findings of the court, and either submit that under the 7-day rule or with a stipulation as to form from Ms. Piper. Mr. Skupin, anything further that we need to address for the record today?
No, sir. I'll have it ordered to Ms. Piper for her approval today. And I'll email it to the court as soon as I get that approval.
All right, thank you, Ms. Piper. Anything further from your side?
Nothing further. Thank you, Your Honor.
Okay, that concludes this hearing. All parties on this file are free to disconnect at this time.
Thank you, Your Honor.
Thank
Have
you.
a great day.
Okay, Ms. Siegel, are you able to hear me okay?
Yes, Your Honor.
All right, we're on the record now in People versus William Thomas Hedrick, case number 224729. The record should reflect that Ms. Siegel's present here today by video. I was notified earlier, Ms. Siegel, that due to a prior commitment, the prosecutor is not going to be present for this case here today, and that the people take no position on the relief requested. This is your motion to withdraw or to vacate appointment of appellate counsel. I did have a chance to review the motion and I am in receipt of a proposed order. Was there anything that you wanted to state for the record today?
Is Mr. Hedrick here?
He is not present.
I did do a writ and I did call Carson City Correctional today to confirm that they received it and they would make him present via Zoom. Gosh, this case has been, Your Honor, this case has been lingering on my docket for a long time on my open cases. And in my opinion, what I'm representing to the court is that it's not my fault, and that I would like it closed. I wanted Mr. Hedrick here so that he could weigh in on it and let the court know if he has some kind of, if he says that it's my fault that he hasn't filed an appeal or something yet and he wants another attorney to have more time. So I guess I'm going to leave it up to the court's discretion to either allow this order to vacate the appointment and kind of let me off the hook. And if he contacts the court and asks for a new attorney, you guys can deal with it then. Or alternatively, adjourn today's motion hearing and I'll do another writ. I cannot understand why he wouldn't be here.
So I am going to
Oh, sorry.
That's okay. I am going to proceed with the hearing today. It's been my experience that even when writs are done, if a defendant or inmate indicates that they don't want to participate or they don't want to appear, then Department of Corrections will not make them appear. So I don't know sitting here whether or not this is a conscious choice by Mr. Hedrick to not appear or whether Department of Corrections does not make him available. I know based on the record before me that that appropriate attempts to secure his appearance today have been made. I think there's adequate relief to the extent that Mr. Hedrick would object to this later on or would seek to have other counsel appointed. He does have adequate relief through the court to address any prejudice that might result from his non-appearance today, if it is accidental or not intentional. So for all of those reasons, I do think it's appropriate to proceed. So that being said, is there anything else that you wanted to say in support of your motion?
Just, Your Honor, that my preference would be that the court order that my appointment be vacated.
Okay. For the reasons stated in your motion, I do think that it would be appropriate at this time. So the court will sign that order. Is there anything else that I can address for the record for you today?
No, thank you, Your Honor.
Okay, thank you. That's all then. You're free to disconnect.
Okay, thanks.
Okay, we're on the record in Johnson versus Chipman. This is case number 24144472. This matter was set for hearing at 3:45. It's now 3:50. Neither party was set as an in-person hearing. Neither party has appeared here at the courthouse or virtually on Zoom. This was set for a hearing on a motion for a personal protection order based on the non-appearance of the petitioner. The court will deny the petition and dismiss the case. That concludes our docket